Hey guys, it's Carolyn. Welcome back to the show. Today we have another episode in all things liens for Nebraska. So I have a construction attorney from Nebraska, Miss Audrey Svane, with Woods Aitken, here to talk to us about Nebraska liens and other construction contracts terms that most people come up against in the industry. Hey, how are you today, Audrey?
Great. Thanks so much for having me.
So before we dive into all things liens and all that good stuff, tell us your background and how you got into construction law.
Yeah, so I kind of fell into construction law by accident. I joined Woods Aitken when I was a law clerk in law school. At the time, had no idea what construction law entailed, but they have a long, rich history of practicing construction law here and a pretty deep bench. So I got to learn from some of the best. We've got offices here in Lincoln, Nebraska, Omaha, Nebraska, and Denver, Colorado, but we really represent various members of the construction industry throughout the country. So I accidentally discovered construction law through my time here, and I really love it. Everybody in the construction industry that I've come in contact with has taught me something new. There's always something to learn, whether that's from the factual side of things, how you actually build something and how to run a business versus the legal issues that we get to run into and delve into. So I've really enjoyed practicing construction law.
I agree, and mostly the clients are very down to earth and easy to deal with for the most part, from my experience.
Absolutely. Yeah.
Okay, so in Nebraska, who has lien rights? Does everybody have lien rights, or is there a cutoff? Or explain me that.
Yeah, so if you were to look at the statute, so we have a statute in Nebraska that kind of governs who has lien rights. If you were to just read that, you might think that everybody's entitled to lien rights. But our Supreme Court has limited who can file a lien. Prime contractors, they're going to be covered. If you have a direct contract with a prime contractor, so you're a subcontractor of that first tier or a material supplier, you're going to be covered. And then if you provide materials, you're a supplier to a first tier subcontractor, then you're going to be covered. Otherwise, it's pretty unlikely that you're going to have a lien right. That being said, because every case is different, I would still recommend you reach out to a construction attorney and talk through the particular facts of your circumstance to see if there's any wiggle room or gray area there to get you lien rights.
Gotcha. Is there any types of trades that are excluded or anything like that specifically, like engineers or anything like that?
No, we don't have any limitations like that. It really is dependent on how far down that chain of privity are you. Yep,
Gotcha.
exactly.
Gotcha. Okay, so usually liens start out with notices. What notices do you have to be sent in Nebraska? Is there a preliminary notice, or is it after the job starts? What notices?
So we're pretty lucky here in Nebraska. I know that some states have very strict preliminary notice requirements. We actually do not have that in Nebraska. So there's no requirement that you file any type of preliminary notice. If you are on a residential construction project and you're a subcontractor, then we do have a process where you can send a preliminary notice, but it's not required.
Okay.
If you're on a project that's a commercial project, then we don't even really have a mechanism for sending any kind of preliminary notice.
Gotcha.
Yeah.
Gotcha. Okay, so then what is do you just file a lien, or is there notice before you have to file a lien?
No notice required before you file a lien. You can just record the lien, and then we do have a requirement if it's a residential construction project that you send a copy of the recorded lien to the owner within 10 days of recording. We don't have a similar requirement if it's a commercial project. We typically still suggest that our clients send in that notice, though. It's a perfect opportunity to send in a demand letter along with a copy of the lien, right? That says, hey, I know you said you're going to get us paid. 30 days have passed. We're going to go ahead and just record this lien to protect our interests. And sometimes we'll tell clients too, right? Because they're nervous about, I don't want to record a lien and then look like I'm trying to escalate things, right? Blame it on your attorney. Say, I know that you can get me paid. I know that you're a good guy. I know we've worked together in the past, but my attorney is a real stickler and they're making me record this lien. So here's a copy of it. Once you get me paid, I'll release the lien, right?
Absolutely. So what is the time frame for filing liens? Is it different for the different tiers? Is it one deadline across the board?
One deadline across the board. It's 120 days from when you last performed work on the project. And again, that's kind of one of those like gray areas for when did you last perform work on the project. Our Supreme Court has come through and said, punch list work is not going to count. So it has to really be significant work, right? And you have to be careful too, if you've got an agreement, either you're a supplier or you're a subcontractor, and you performed one scope of work and then you haven't been on the job site for a while and you enter into a new agreement to perform a different scope of work, and there's enough of a break there, you might have an issue where a court looks at that and says that's really two separate subcontracts, right? So you have to be careful. You can't just kind of perform new work to extend the time period for filing that lien right. So make sure that if you're not getting paid, you get that recorded within 120 days of when you last performed work.
Is there any penalty for filing it early?
There's not. You could file right after you have the contract signed and executed. We do have kind of a limitation on how much you can claim, though. So typically the amount of your lien is going to be the amount of your contract price. If there's already been substantial completion or substantial performance, though, you can actually include breach of contract damages in your lien amount.
Really?
So, I mean, that you might want to amend your lien if there has been some kind of breach and you think you're going to ultimately be filing a lawsuit to increase the amount of your lien.
Gotcha.
Yeah.
So you can amend it, but it's got to be within that 120 days, or can you amend it after the 120 days?
You can amend it within the 120 days upwards. So if you're going to increase the amount that you're seeking, right? Or you're going to add additional parcels. So maybe it's like you're doing construction and there's a couple of different pieces of property. Otherwise, you can amend it after the 120 days, but it has to be to reduce the amount of your lien or to reduce the property that you're like claiming the lien on.
We can make it less, not more.
Right. Yeah,
And
exactly.
where are liens filed in Nebraska?
They're filed with the Register of Deeds in the county for where you performed the work.
Gotcha.
So yeah, and it's nice now because most counties in Nebraska will let you use simple file. I don't know if you've used that before. Like
It makes it so easy.
Awesome. Yes, yeah, right. Before you'd have to like mail it to the county, hope the Register of Deeds got it, and turned it around very quickly.
Exactly.
So it's nice to have instant feedback.
Exactly. I truly appreciate that. So once a lien is filed within 120 days, is there any limitation to the owner's liability, or they have to pay twice if they've already paid the GC? Is there any limitation to the owner's liability?
Yeah, so it kind of depends if it's a residential project or a commercial project. If it is a residential project and you're a subcontractor and you sent in that preliminary notice, then there potentially could be double exposure for the owner. So the owner, if they were aware that there were other trades that were performing work that they didn't have a direct contract with, and they got that notice, then they kind of have an extra responsibility to make sure that the subcontractors are being taken care of instead of just making payments to the general and assuming the general is going to take care of it. That's the benefit of doing a preliminary notice on a residential project.
Gotcha.
Otherwise, if it's a commercial project, there's not really another avenue, I guess, to have additional liability for the owner. So if the owner can prove I made payments to the prime contractor, they didn't issue payments to you, that's going to be kind of an affirmative defense that the owner can raise to limit their exposure in the lawsuit.
Gotcha. So actually filing sooner would be better because, or at least putting them on notice somehow before they pay the GC that you're owed money.
Right. And we don't have like a huge amount of case law here in Nebraska on the Construction Lien Act or kind of other construction issues. So what I would say is like always communication is going to be your biggest friend, right? So if you're having issues, just letting the owner know does two things. One, it creates that notice so that if later you want to show that they knew that there was this potential party out there that wasn't being compensated, right? That's a benefit. And our judges are going to look at that and say, okay, you knew that there was a potential here. You should have asked questions. Two, it also gives you a little bit of leverage, even in negotiating with the prime contractor, because you can, the owner knows that there's an issue going on here. They don't want to have that lien filed on their property. So if they know that there are issues, maybe you help get it resolved just because there's pressure coming from upstream as well.
Yeah, because at the end of the day, the goal is never to file a lien. The goal is to get the client paid. And so whatever can do that, just, sending a notice, even though one is not required, is okay. You can always send extra notice. You just can't.
Absolutely, yeah.
Not send what's required. Okay, so once the lien is filed, how long is it good for? How long do you have until you have to file suit to enforce it?
Typically, it's 2 years. So usually you have to file a lawsuit within 2 years of recording. However, we have this mechanism in Nebraska where you can speed that up. So if there is a lien that's been properly recorded, the owner can send what's called a demand to initiate judicial proceedings.
Okay.
And the party that gets that has to either file the lien foreclosure lawsuit within 30 days of receiving that demand, or they can file an affidavit with the county register of deeds that says the amount that they liened is not yet due. So you file a lien beginning of the project, that amount's not due yet. If they got the 30-day notice, you could say, wait a minute, I've only been performing work for a couple of weeks. I'm not going to file a lien foreclosure lawsuit on this. But if you do get that 30-day notice, it can speed up the time to file. And if you don't file within that 30 days, your lien is no longer enforceable. Yeah.
Gotcha. All right. What about the recovery of attorney's fees in a lien foreclosure action?
Unfortunately, there are very few chances in Nebraska to recover your attorney's fees. There is a mechanism under the Act to recover attorney's fees if somebody interferes with your lien rights. So, for example, if you could show that an owner or an upstream party gave you the wrong property description intentionally to screw with your right to file a lien, then there's a mechanism for us to get attorney's fees in an action. But otherwise, if it's just a typical lien foreclosure action, attorney's fees are not recoverable, unfortunately.
That's a rough one.
It is.
So, okay, when you send out a notice of lien after you record it, does it have to be certified mail, personally served? What does that look like?
The statute doesn't specifically call for anything. I always say certified mail so you can show exactly that it was delivered within that 10 days. Just to, double cross your T's, dot your I's.
Is delivery required or just a proof that you sent it?
Just the proof that you sent it is required. But again, having that confirmation that it was received is always helpful.
Gotcha. All right. Well, wow. It's pretty simple there. So I've kind of studied the lien rights in all 50 states, and every state does it differently. This is actually quite easy comparatively. Texas is all kinds of messed up. We have lots of notices and lots of stuff we have to do.
I know. We've had clients before that perform work down in Texas, and so I've read through just like some secondary sources about here's how to send your lien trapping notice, and you guys have so many hoops to jump through. It really is a landmine out there for contractors, and you got to remember, if you're performing work in a place you haven't performed work yet, you got to reach out and ask questions because, like you said, it can be different. Yep. From state to state. Yep.
Yeah, because like California's got a 20-day preliminary notice, so does Florida. And like if you don't send it, then you don't within 20 days of first work, then you don't have lien rights.
Yeah. Wow.
And you're waiving it before you even know. Okay. Right. Before I go on to some other contract terms I want to talk about, is there anything I'm missing that you wanted to bring up on the lien statute?
This is the big stuff. I would say that in Nebraska, you can waive your lien rights before you start work on a project. And
in
so
a contract, can you do it?
Yep. So just being extra cautious, right? About if you've got a contract provision that says, I'm not going to file a lien on this project. That might be enough because we construe lien waivers pretty broadly here. Okay. So just don't assume that even though it sounds like it would be pretty bad for you, that it's not enforceable because here, if you contractually agree to waive your lien rights, whether it's a separate document or it's included within your contract, then a court could say, you know.
Wow, and it's very different. Every state is very different on that one. Like Texas is no by case law. I know there's several states that are that you can pre-waive your lien rights.
Yeah.
Interesting. All right, bond claims. I wanted to touch on that real quick for public.
Yeah, we do have a little. So we do have a little Miller Act that covers bond claims here. Again, the time period for sending in your demand under the Miller Act is going to be different than the time that you have to record a lien. Generally, you have to send notice if you are a lower tier. So if you don't have that prime contract, you got to send notice within 4 months. And then the time to file a lien is 90 days after or 90 days before the work is substantially complete. And I'm just trying to remember off the top of my head, but the deadlines are different. So if you are going to be performing work and it's a public project and there are no lien rights and you're going to be limited to filing a claim on the bond, make sure you know what those deadlines are ahead of time before you start work, because there may be a notice requirement depending on what tier you're at. And then there is going to be a timeline for when you can file on that bond. And that may be different depending on the particular language in your bond, right?
Really?
So your bond may say you have more time or you have less time. And so making sure that you're aware of what all of those are before you start work, so you're protected if something does happen.
Absolutely. Absolutely. All right. So tell me how the Prompt Payment Act works in Nebraska.
Yeah, so our Prompt Payment Act is pretty broad. It's still fairly recent. So again, we don't have a lot of case law from courts to help us interpret it. But it is going to apply both in the private construction context when you don't have a public owner involved. And it also is going to apply when you have a project with a public owner and the state is not involved. So if it's a political subdivision, which could be a school, a county, a city, and there are no state funds involved, then our Prompt Payment Act is going to apply, as well as if it's just purely a private matter. It does not apply in residential construction context, so just in commercial construction. Yep, but it pretty much follows your agreement. So if you have a contract or a subcontract that has certain conditions precedent to payment, arguably the way that our act is written, you might have to still jump through those hurdles and hoops in order to have a claim under the Prompt Payment Act. Again, unfortunately, it's a little bit unclear because it is so new. But in general, the requirement is that the owner issues payment to the prime contractor within 30 days of getting a request for a payment. And again, making sure all those hoops or conditions in your contract have been satisfied. And then the general contractor has an obligation to issue payment to its subcontractors within 10 days of receiving payment from the owner. And then the subcontractor has the same requirement downstream. So if they've got suppliers or subcontractors, they have the requirement to issue payment within 10 days of receipt of payment from the prime contractor.
Gotcha. And what's the penalty if they don't?
Interest. It's 1% interest, and you actually have to notify the party that was supposed to pay you. You have to notify them of the Prompt Payment Act before that interest starts to accrue. So again, this is another opportunity where if you did record a lien or you just want to send a demand for payment, including that citation to the act is really helpful because it starts that clock ticking on interest. And the other benefit of our Prompt Payment Act is it does include a provision for attorney's fees. It's a little bit of discretion up to the court whether they want to award attorney's fees or not, but it does give you that potential. And this is kind of the first time that we've had that in Nebraska. So that's an exciting addition, that if you're a plaintiff and you file for violation of the Prompt Payment Act, you might be able to recover attorney's fees.
Well, and it's a pretty good bet that if you haven't gotten paid, somebody up the chain got paid and didn't pay you.
Right. Unfortunately.
And you can throw in the lien foreclosure, and then you can get recovery of your attorney's fees or some of
right.
them.
Yeah. In the best case scenario.
All right. The last issue I wanted to touch on is the paid when paid clause. And in most states, it's enforceable. Is it enforceable in Nebraska?
Yeah, we don't have a case that says it's not enforceable. Again, at least we have the Prompt Payment Act that you can kind of use as a sword if you're not getting paid. But on the front end, we would always suggest not signing a contract that says, I'm agreeing that I'm not going to get paid unless and until you get paid.
Exactly.
So,
exactly.
Yeah.
Unfortunately, it's like one of the biggest, most contentious terms in subcontracts.
Right.
And as long as everybody keeps signing it, I think it'll be around. So.
Right. And I mean, I guess if you made the business decision that you're willing to agree to a pay when paid, that's fine. But you might need to do some extra investigation on the front end to figure out, who is this owner? Are they big enough? Do they have assets so that if something goes wrong halfway through the project, they're going to be able to issue payment? Or am I putting myself in a position where, something goes wrong, there's not going to be money at the end of the day?
No, exactly. And I always tell my clients to be able, if you sign a contract with a pay when paid, you got to be able to cash roll that whole contract without getting paid potentially. And don't be wrong, you can always file a lien if you're not paid, but the fact is, just because you're not paid doesn't give you the right to stop working.
Right. And that's hard for a lot of contractors to do. It's expensive work. So having that much within your company that you're able to kind of keep everything afloat when things go wrong, a lot of people just can't do that.
No, absolutely. Well, this has been great. You're truly an expert. I truly appreciate this. Where could people find you and contact you if they need help in Nebraska?
Yeah, so I'm on LinkedIn with my name, Ace Svane. That's S as in Sam, V as in Victor, ANE. You can find me through our firm's website, woodsaitken.com, and Aiken is AITKEN.com. And all my contact information is on our website. So if you have questions and you're performing work in Nebraska, feel free to give me a call. We have a lot of white papers too. So, even if you just want here's the quick fact sheet for doing work in Nebraska, what are all the various deadlines? Sometimes that's helpful to have on the front end of a project. So your project managers and your people in the field know, hey, if something goes wrong, we got to move quickly. These are our deadlines.
Gotcha. Well, thank you so much for being on the show. I truly appreciate it.
Yeah, thanks for having me. I appreciate it.